Okay, good morning, everybody. Welcome to VWV's June Employment Law Update. I'm Michael, and you can see my colleague Mark there. We'll be taking you through the slides today. There's a couple of points to make before we set off. The first one is that we're going to cover a couple of election-related matters today, but in July, the next employment law update, there'll be a detailed look at the employment law implications of the general election. So try not to miss that one. The other thing is that during the course of the webinar today, we'll probably store up questions for the end. So if you have any questions, there's a Q&A box, you can stick them in, and we'll try and get through as many of those as we can towards the end of the seminar. If you've got any technical issues or problems, stick them in the chat box, and we'll do our best to help. And just to say that you will get a copy of the slides and this recording after the event sent to you as well. So if we move on to the first slide. So this is an overview of what we're going to cover today. I will cover something about the general election and the right to request predictable working pattern, which is slightly connected with the election as well. I'll then cover a sort of overview of the prevention of the duty to prevent sexual harassment. And then I'll pass over to Mark, who will cover the case law update. So if we, I think, launch straight into the first one of those about the general election. So this is about the parliamentary wash-up, and that's a bit of jargon, I suppose. The wash-up is a term used for the period between when a general election is announced and when Parliament is dissolved. So in this case, there were 2 days during that period, and the government uses that period to try and get through what might be seen as less controversial bills or bills with partisan support quickly to get them onto the statute book. Looking at the first of them, the Paternity Leave Bereavement Act 2024, this is the act which provides for paternity leave in cases where a mother or a person with whom a child is placed or expected to be placed for adoption dies shortly after the child's birth. So this is going to be a day one right, and the intention of the bill is that the bereaved father or partner will have 52 weeks leave available during the first year of the child's life. There's no date for that coming into force at the moment, but it appears that the intention is for the new rights to be enforced by April 2025. And this has bipartisan support, so it will happen. The next point there is the draft statutory code of practice on the fair and transparent distribution of tips. And the underlying Allocation of Tips Act is intended to prevent exploitative practices like deducting administrative fees from employees' tips, and the Code of Practice provides guidance on how to allocate tips fairly. The Act has been approved by Parliament, but the Code requires some further regulation to bring it into force, and that's expected to happen in October. And it has, again, bipartisan support, and both parties support the idea of 100% of tips going to staff. The third and fourth points on the slide relate to dismissal and re-engagement. So dealing with the third one first, you'll be aware that after the P&O redundancies in 2022, the government committed to tightening the rules around dismissal and re-engagement, or often referred to as fire and rehire in the press. And prior to the election, the government approved a code of practice setting out a process for an employer to follow where it's considering making changes to employees' contracts of employment, and envisages that if those can't be agreed, it may opt for dismissal and re-engagement. So if nothing's done by the party that wins the general election, the code will come into force on the 18th of July, including a 25% uplift for an unreasonable failure to follow the code. So if the Conservatives win the election, that's what's going to happen because it's their legislation. If Labour win, it's not quite so clear. It seems likely they would allow the code to come into force and seek to strengthen it at a later date. The Labour Party agrees that there should be regulation in this area, but generally takes a stronger view about how the regulation should operate. So it would probably strengthen those the code of practice. Now, there is an intention that there should be a 25% uplift on the protective award for failure to follow the code in cases of collective consultation. So that's cases where there are 20 or more employees at one establishment who may lose their jobs within a 90-day period. That will only come into force if the winner of the general election passes the order mentioned in the final bullet point there. If the Conservatives win the election, then of course they will do that, but it's not so clear what Labour would do at the moment. Again, they may pass that because it's something they could do quickly and does provide some protection. The alternative might be that they want to provide a more systematic type of protection, so they'll hold off on that in order to do something more to their liking. So moving on to the next slide, which is a quick look at some of the key Labour Party proposals. And this is not a party political matter. I think we're all fairly familiar with the governing party's views around employment legislation, and of course we've lived with that for many years. So it's just a quick look at what the opposition and potential government may be proposing. So the first one is tighter controls on zero-hour contracts. And Labour's made banning what it sees as exploitative zero-hour contracts one of its flagship policies, and creating a right to a contract based on average working hours. It's not clear how that will operate in practice, and I guess it would require quite a lot of consultation potentially, so it probably won't happen overnight. The next is single worker status. Now, this is a very complicated and difficult area to legislate on, and it's really been discussed for many years. I think the Taylor Review back in 2016 talked about it in some detail. And Labour's committed to a full and detailed consultation and a move towards single worker status. But that isn't likely to come into effect very quickly because it is such a complicated and difficult area to deal with and impacts very directly on what people call the flexibility of the workforce in general. The next is the change to a 6-month limitation period for employment tribunal claims. Most claims at the moment have a 3-month limitation period, which can be affected by early conciliation and other things. But the Labour Party's view is that should be moved to 6 months to allow employees time to assert their rights. The next one is unfair dismissal to become a day one right. Now that certainly would be a significant change. It's not something that we would be used to at all. The current qualification period is 2 years. It has been 1 year in the past. That was held many years ago to be indirectly sex discriminatory, so it was moved to 2. No, the other way around. But anyway, there has been movement between 1 and 2 years, but there's never been a removal of the service requirement completely. So it's not clear how that would work in practice, and it's likely that there have to be quite a lot of consultation again for such a change, and how that would accommodate probationary periods, which Labour have said they want to preserve. What the policy document says, I'll just read a little bit from it. It says, we will ensure employers can operate probationary periods to assess new hires. However, the changes will help to ensure that newly hired workers are not fired without reason or cause, and will help drive up standards in workplaces. Okay, so that change is coming. It's just not quite clear how it will happen and how quickly it will happen. The next one is the removal of the compensation cap for unfair dismissal cases. Now, the Labour Party originally said that it would drop the cap, but that's not currently included in their most recent policy document around employment law. So the cap at the moment, just make everyone aware, is around £115,000 or 12 months' salary, whichever is the lower. And Labour's plan had been to remove that, but it's not quite clear now whether that's still part of the policy or not. And the final point on the slide talks about the removal of service requirements. And if you read the Labour Party's policy document on employment law, there is a general thrust to move away from service requirements, such as the 2-year qualification period for unfair dismissal and 26 weeks for various family rights, and move to day one rights where possible. And in the Labour Party's view, that allows people to move jobs without losing job security. So I've mentioned unfair dismissal already, and there are proposals in the document to also make parental leave a day one right. It's not clear if that just refers to parental leave as it currently stands, which is 18 weeks leave up to a child's 18th birthday, whether it also covers leave such as paternity leave. So some other headlines, I mean, those are some of the key points. Labour Party has set out a lot more detail in its New Deal for Working People, which is easily available if you're interested. And some of the things in there, for example, also include ethnicity and disability pay gap reporting and changes to the national living wage to take account of cost of living and the removal of the age bands of the national living wage. So moving on to the next slide. This is to do with the right to request predictable working patterns. So the Predictable Terms Act received royal assent in September 2023, but it needs further regulations to bring it into force. This means the future of the Act is uncertain. If the Conservatives win the election, we can expect it to come into force in the autumn. If Labour win, then it's not clear what will happen. Whilst they are in favour of creating more predictable working patterns, they may well prefer a different approach to that set out in the Act. At the moment, I'm not aware that they've expressed a view, although their workforce plan does accept that the current government has made a start in this area. So the current plans, as planned by the Conservatives, is a right to request predictable working patterns, which can be refused on a series of statutory grounds. So it's much like the flexible working regime, which we'll all be familiar with. They'll be allowed to make 2 applications in every 12 months, and there'll be a 26-week service requirement. As I've said, Labour's workforce plan is more focused on day one rights and tackling what it sees as sort of one-sided flexibility in the employment law area. So this might point towards a longer-term aim to require jobs to provide a baseline level of security rather than having a right to request as planned by the current government. So whilst I think employers should expect something on predictable working patterns over the next 12 months, because both parties agree that something should be done, given the current political uncertainty, we'll have to wait until after the general election to see what sort of regulation emerges. And I guess we'll be able to cover that in more detail in the July webinar. Having said that, I think that there is a forward to the draft ACAS code mentioned in the final bullet point there. And that provides some observations, I think, which give a useful indication of the direction of travel, no matter who's in number 10. So in the code, ACAS say the following, amongst other things, but these are some of the key points, that all employers should regularly review their arrangements for flexible contracts, which should always be used responsibly and fairly to ensure they're working in the interests of business and the interests of the workers. If there's a request for a predictable working pattern, this should be handled in a reasonable manner and should be given careful consideration, which means balancing the needs of the business and the individual involved. And in the absence of genuine reasons to hire casual staff on flexible contracts, the default should be predictable working patterns. And finally, employers should turn their minds to whether there are alternatives to unpredictable casual working patterns. So those are the sort of things which are said in the current draft code, and I'm guessing that whatever political party takes this forward, those sort of ideas and that ethos will be embedded in the law somehow. So moving on to the next slide. This is a recap around the prevention of the duty to prevent sexual harassment. So the Worker Protection Act 2023 comes into force in October 2024, and that's been well trailed. And the Equality and Human Rights Commission will be providing guidance for employers on how to comply with that duty. The new duty is on employers to take reasonable steps to prevent sexual harassment in the course of employment. And it introduces a potential to maximum 25% compensation uplift where an individual brings a claim for sexual harassment which is successful, which also demonstrates a breach by the employer to comply with their duty. It will only be the EHRC who can enforce the duty on a standalone basis. And they will provide technical guidance, I've said, to help employers, and that's probably going to be in September 2024. The technical guidance will include what amounts, or a description of what amounts to reasonable steps, which is of course going to be the key for all employers to understand. And whilst the details not known, we can probably, with some certainty, predict it's going to include some of the following. And I'll go through a few issues which probably be familiar to you all, but we should all have in mind as this change comes onto the horizon. First is having a clear and regularly updated policy specifically dealing with sexual harassment. Providing mandatory training for staff on what amounts to sexual harassment and the standards of behaviour expected in the workplace, how to raise a complaint, and additional training for managers on how to handle those complaints. Having a zero tolerance workplace culture in relation to sexual harassment, which is openly supported by senior management. Encouraging the reporting of sexual harassment and providing appropriate support to those who do report a complaint. Conducting regular staff surveys to ascertain the extent of any problem that might exist in the workplace. Taking effective measures to help minimise the risk of sexual harassment by third parties. Monitoring the progress of all sexual harassment complaints to ensure they're properly investigated and resolved. And also monitoring the progress of employees through the workplace who've made complaints or are witnesses in investigations to ensure there's no victimisation taking place later on. And finally, having workplace champions in place to support and advise those who experience or witness sexual harassment. So all employers, as I've said, should be thinking about how to embed these measures in advance of the Act in October, but there will be more helpful guidance from the EHRC as the autumn comes along. So those are the end of my slides, and we'll move on to the case review with Mark.
Thank you, Michael. Good morning, everybody. I'm going to start with a Supreme Court judgment, the decision of the Supreme Court that's relatively new. Mrs. Mercer is a trade union representative. She was a representative of Unison, and as part of a labour dispute that was taking place at her employer, she gave some statements to the press. Her employer was upset by this and suspended her. They subsequently pursued disciplinary action against her. Mrs. Mercer argued that she had been subjected to an unlawful detriment for taking part in industrial action. And she argued that there's protection under TUPE against workers who participate in industrial action from being punished for doing that. The case looked at the legislation itself in quite a lot of detail, and the issue for Mrs. Mercer was that Section 146 of TUPE does not provide specific protection in relation to workers being subjected to a detriment for taking part in industrial action. What the legislation protects is employees who are dismissed for taking part in industrial action or suffer a detriment and are dismissed for taking part in industrial action. There's no standalone protection in relation to merely, in inverted commas, a detriment being suffered, as in this case. Mrs. Mercer's detriment was that she had been suspended for participating in the industrial action. The Employment Tribunal looked at this, the Employment Appeal Tribunal looked at this, and the Court of Appeal looked at this and reached the same decision, ultimately, that protection just was not there in the legislation. The Supreme Court issued their judgment in April 2024, and unfortunately for Mrs. Mercer, the same decision was issued. The legislation just does not provide the protection against a detriment for taking part in industrial action. The Supreme Court did go further, however, and issued a declaration of incompatibility with the UK legislation with Article 11 of the European Convention on Human Rights. Article 11 of that convention, of course, is the right to freedom of association, including trade union activities. What does the declaration of incompatibility mean? Well, what it is it is a red flag that is raised with Parliament to tell Parliament that domestic legislation does not comply with the European Convention of Human Rights. What this declaration of incompatibility doesn't mean is that the law is invalid or doesn't apply. It's simply a message to Parliament that this is an issue, this is something that Parliament should turn its mind to. Now, clearly, and as Michael has been talking about, we don't have a Parliament at the moment. Things will become clearer in July, and it may well be that providing protection to people engaged in trade union activities is something that a new government may see as important, as even a priority. But for the moment, people in Mrs. Mercer's position are not protected against being treated less favourably, being subjected to a detriment for participating in industrial action. Now, of course, there may be many good reasons not to subject somebody who's involved in industrial action to a disciplinary process or suspend them, not perhaps because they don't have protection against under TUPE, but it's clearly going to impact your labour relationships if trade union representatives are subjected to detriments, they are suspended, subjected to disciplinary procedures for participating in that industrial action. So there's probably still some good reasons not to subject workers to detriments in those circumstances. Moving away from the Supreme Court, this case of Groom and the Maritime and Coast Guard Agency looks at the question of volunteers and when a volunteer could be considered to be a worker and therefore receive some protections under employment law. I suppose it's helpful to just think about the three different sort of types of employment status. Self-employed individuals, people who are in business on their own account, do not have specific protection under employment law, save in respect to discrimination complaints. We then have a worker status, who are not employees, but they have a level of protection that is not provided to self-employed individuals in business on their own account. Workers are entitled to be paid the national minimum wage. They're entitled to be paid to receive paid annual leave and have other protections in law. And then finally, you have the employees. Employees have the highest level of protection. They have a whole suite of of protections. Employers have obligations to their employees, not least not to dismiss them unfairly after 2 years service. In this case, the claimant was a volunteer for the Coastal Rescue Service. He'd received a volunteer code of conduct, which he was required to follow. But importantly, he was required to attend a training courses and was entitled to submit monthly payment claims to cover certain payments that he was entitled to. Basically, if he was called out, he was entitled to some compensation, effectively, for the disruption that he'd suffered as a consequence of that. Particularly, there was a recognition that things might happen in an emergency situation during unsociable hours, and as a consequence, he was entitled to put a claim in to receive some compensation for that. Whilst Mr. Groom himself did not actually make such claims, and many other volunteers did not actually claim in those circumstances, the fact that there was an entitlement to a level of remuneration for the activities that were undertaken meant that Mr. Groom was able to argue that he was in fact a worker and he wasn't a genuine self-employed individual or a volunteer who was not entitled to any payments at all. As a consequence of that, he had a level of protection that the Coast Guard agency hadn't anticipated. He was entitled to be paid in accordance with the national minimum wage and also entitled to paid annual leave. This is, I suppose, a case. I mean, as always with these sort of employment status cases, they turn very much on their facts. So you can see how individual circumstances will change and impact the status of the individuals involved. But this is a bit of a cautionary tale, I suppose, for where an organisation is using volunteers and feels that there would be an opportunity to, in some way, compensate those volunteers for their time or recognise disruption caused to a volunteer's life by the assistance that they've been providing. There's a risk in doing that, and I think this is a case where, unfortunately for the Coast Guard agency, they were on the wrong side of that, and perhaps through an attempt to be generous, they ended up conferring a status upon Mr. Groom and others that wasn't always their intention and created legal risk for them. The next case involves a school and is related to discrimination. Baldwin against Cleves School looked at whether or not a discriminatory act could be performed by individuals could be attributed to an employer. In this case, Ms. Baldwin was a newly qualified teacher until she resigned, and the resignation was attributed to the behaviour of two other colleagues, two other teachers within the school. She pursued employment tribunal claims against the school and also those two individuals. Of course, we're probably all aware that discrimination complaints can be brought both against an employer and also a named respondent, a named individual who the claimant alleges was the perpetrator of the discrimination. The employment tribunal found that the school was liable for the acts of discrimination committed by the alleged two perpetrators. The employment tribunal, though, went on to say that because they'd found the school responsible for the acts of those two alleged perpetrators, that those perpetrators themselves had no, the claims against them were dismissed. So those two individuals had no personal liability to the claimant in those circumstances. circumstances. The claimant appealed, and the Employment Appeal Tribunal upheld the discrimination claim against the school, but also said that the two individuals who were the alleged perpetrators were also legally responsible. They, in this circumstance, couldn't successfully argue that because they were assured by the employer that the act was lawful, that was sufficient for them to avoid personal liability. No, the Employment Appeal Tribunal said that the claims were upheld against all three respondents, and the fact that the school had been found liable for the two individuals' actions didn't necessarily mean that they were off the hook. The position becomes, I suppose, the question of who is to blame ultimately for the discrimination then is a matter for the tribunal to look at when it decides what compensation to award to a successful claimant. At what level of compensation should be attributed to each respondent. But from a legal position, from a liability position, both the school and the individual respondents, the named respondents, were legally responsible for the discrimination. Sticking with discrimination complaints, this case involved a TUPE transfer. Many will be familiar with the TUPE regulations, which work to transfer the employment of employees from the outgoing employer to an incoming employer. In these circumstances, very much a case that's got individual facts. There was a harassment allegation made by the claimant who alleged that they'd suffered discrimination at the hands of a colleague. The claimant subsequently resigned. They left their employer, and before the discrimination claim was heard, the colleague's employment was moved away to a new employer in accordance with the TUPE regulations. The claimants, of course, who'd resigned by that point, did not transfer alongside their colleague to a new employer. The old employer said that sorry, just bear with me. The old employer said that the responsibility for the alleged discrimination had transferred with the colleague, the perpetrator. That as a consequence of that, the old employer said that they were no longer responsible legally for the wrongdoing of the colleague, because under the TUPE regulations, all rights and obligations in relation to that colleague had transferred to the new employer. So they were the ones who were stuck with the discrimination claim. The Employment Tribunal didn't agree with that argument. The liability for wrongdoing arose in connection with the claimant's employment, so the alleged victim of the discrimination, and not the perpetrators. So the liability for the claimant's claims stayed with the first employer, stayed with the initial employer, and didn't transfer with the perpetrator across to the new employer. So there was no opportunity for the old employer to get off the hook in those circumstances, which is, I'm sure, a relief to the new employer, because they would have been concerned, and I suppose this is why it's important to think about your due diligence that you do in advance of a TUPE transfer. They would have been concerned about inheriting liability in those circumstances. I suppose the position would have been different if the claimant had actually transferred along with the perpetrator, because both would then be employees of the new employer And you could see how in those circumstances the liability would have gone across with the claimant to the new employer. But that's not what happened in this set of circumstances. This is a case of disability discrimination. The specific issue here for the claimant was whether a employer, the insolvency service, had knowledge of, had awareness of a disability. In this case, the claimant had a stammer and sought to apply for an internal promotion. As the slide explains, he was very close to getting that promotion. He missed by 1 point. The employee subsequently challenged the fact that he'd missed out on the promotion and argued that the reason for his failing to get those additional points was related to his stammer, and specifically because he argued that his stammer caused him to go into what he referred to as a restrictive mode, that therefore meant that he was unable to answer questions in the most forthright and clear, concise way. He alleged that there had been a failure to make reasonable adjustments, and that the decision not to promote him amounted to discrimination arising from a disability, arising from, in this case, his stammer. But the tribunal, and then subsequently the Employment Appeal Tribunal, rejected those claims and said that the employer, in this case, was unaware that the claimant had a disability. The claimant hadn't done enough to formally raise the fact that he had a stammer and was moving into restrictive mode, and that was impacting his ability to participate in the interview. And as a consequence of that, there could be no disability discrimination in these circumstances. From the insolvency service's perspective, the employee had actually performed very well during the interview and had only just missed out on the promotion, so had got very, very close indeed to being promoted. And as a consequence, there was insufficient information available to them that the claimant was in a position where he was that there was an obligation on the respondent, the insolvency service, to make reasonable adjustments to help him participate. So again, it's an interesting case about knowledge. I think for me, it's always difficult to argue knowledge in a disability discrimination claim from an employer's perspective, because employers can have constructive knowledge of a disability. You don't always, as an employer, need to have been actually told that somebody has a disability. If it's clear, or should be clear, that they do have a medical condition that meets the definition of a disability under the Equality Act. This was a case, though, where the claimant's performance was such that no constructive knowledge could have been implied in these circumstances. So that's a counter through some of the key cases that have come out over the last four or so months, and it brings us to the end of the formal part of this webinar. Michael, I don't know if you can see whether we've received any questions.
Yeah, we've received some questions which we can run through. So I'll read those out, and we'll see how we get on with them. So looking at the first one, it's about single worker status, and the questioner asks, are there likely to be exceptions as much of higher education teaching is provided by self-employed workers? That's a good point. And of course, we don't know what the detail will be, but I had a quick look at the Labour Party's document on their proposals around employment law. What they intend to do is to merge employee and worker status. And so you end up with two categories. One is the genuinely self-employed, and the other is a single status worker, which will be akin to an employee, I guess. So the self-employed element will be preserved. Do you want anything to add to that, Mark, or shall I move on?
No, I think that's
fine.
That's clear.
So the next one is what's the difference between a code of practice and an act? Are they effectively the same in practice from an employment perspective? Well, I can cover that, Mark, or do you want to?
No, I mean, please do go ahead.
We're going to defer
really
to each other as we go. Yeah, I mean, I can see from a employer's perspective, the two are pretty similar, but from a legal perspective, the underlying act sort of brings in the legal framework and the legal responsibilities, etc. And the code of practice is often facilitated by that underlying act. So the code of practice brings in the detail, which allows you to comply with the obligations under the act. And recently, of course, we've seen many codes of practices through ACAS have measures in place if you fail to comply with the code, usually uplifts of up to 25%.
And that works both ways, doesn't it, Michael?
Yeah,
Because
absolutely.
I suppose most obviously, if an employer fails to comply with the discipline or grievance code of practice, there can be an uplift of up to 25%, for instance, if there's no appeal put in place for somebody who's dismissed. But it also does work against a claimant as well, potentially, if issues that they pursue in an employment tribunal haven't been raised in a grievance, or the appropriate grievance process wasn't followed. But yes, I think codes of practice, yeah, I mean, clearly they are very, very important, and for all practical purposes, it's about complying with them in the same way that you would comply with the law.
Yeah, absolutely. Good. And the next one is, does the Sexual Harassment Act cover harassment from fellow workers and customers' clients, or just fellow workers? So there's a bit of history around this. Probably don't need to go into too much detail, but the upshot is that liability for the acts of third parties was removed from the amending act. So the position is that employers are not liable for the acts of third parties. Such, this commonly comes up in the entertainment industry, where waiting staff are subjected to comments from customers and third parties, etc. However, the duty to prevent sexual harassment, that is accepted, that would extend to obligations on the employer to take reasonable steps to prevent the sexual harassment of employees by third parties during the course of their employment. So one could imagine that an employer may fail to take reasonable steps and therefore fail to comply with its duty if it knowingly sends staff out to deal with customers who have already abused other members of staff or things like that. So the duty will be there, and if your staff deal with third parties, which is commonly the case now, not just when in the entertainment industry, but also a lot of us work alongside other organisations on a commonly. So it's going to be an increasingly interesting area, certainly. Do you want to add anything, Mark, or should we move on?
No, I agree. Let's
I
agree.
Yeah. And at the moment, the next one, it's the final one in the box at the moment, is would dropping the employment qualification period also apply to redundancy rights? So I didn't look at that specifically, but I guess what we'd be talking about there are redundancy rights would split, wouldn't they, into unfair dismissal. So at the moment, once an employee has passed 2 years, if you make them redundant, you must follow a fair process to ensure the process ensure the dismissal is a fair dismissal. I guess if unfair dismissal rights trigger from day one, then you'd need to make sure that fair process was followed for every employee, which you may already do so as a matter of good practice, but there'll be legal ramifications for those staff under 2 years if the law changes. Around statutory redundancy payments, I don't know offhand whether the current service requirement will change, because those redundancy payments obviously provide a cap on weekly pay, but it's multiplied by the number of years that you work. So until you complete a certain number of years, you don't qualify for redundancy payment. I would have to check that because I don't know the answer. It's a good question, whether the Labour Party has proposed anything specifically on that. I'm not aware of it, having looked at the policy documents, but I suppose that if there is a general move towards day one rights, then one might think there might be potential move around qualification for statutory redundancy. But it's worth remembering that those redundancy payments have always rewarded long service. So even if there were a change, I'm not sure it would be significant for those with very short service.
No, I mean, that must be right, mustn't it? I mean, that's what the statutory redundancy payment is sort of there to do. The ethos behind it is to recognise the service that an employee has given, and to provide some financial recognition of that time. But yeah, I mean, I think that would be very, very interesting, and I think just the whole concept of unfair dismissal being a day one right would drastically change a lot of the sort of decisions that employers would be making within a short period of time after an employee starts.
Yeah, and that leads nicely on to another comment that's come in, which is someone says, I cannot see how day one unfair dismissal right can work in the context of probation period. Surely this will cause real problems for employers. And, you know, I can understand where that's coming from, because it's not something that we're used to. And you've got 5 potentially fair reasons to dismiss for employees over 2 years. And one can understand that after 2 years, there's been a very good opportunity to assess someone's suitability for a role. It's potentially too long, you know, in many people's point of view. But so you can see how those 5 fair reasons work in that context. If it's unfair dismissal from day one, you know, leaving questions of discrimination aside, but what if there isn't a fit? What if there is just a sort of personal dislike in small businesses, for example, or other things? How do you know, that would usually be flushed out in the probationary period, but those things wouldn't usually amount to fair reasons to dismiss. So we'll have to see how they work to ensure flexibility within probationary periods, as well as having a day one right. And I've found a little bit of relevant text in the document, the policy document. It says, it's the Labour Party one, obviously. This says, therefore, we will move towards a single. That's the other bit I highlighted. Oh, I've lost it now. I won't search for it with you all there. But essentially, that says that the party will seek to ensure that there is flexibility around probationary periods, but that no one will lose their job for an arbitrary reason. So how that works in practice is we're not really sure yet.
Yeah, I mean, it's a really, yeah, it's a good question. I think as with many of these things will have to become clearer over subsequent weeks and probably months. It would be a big change. I'm really interested seeing how to what extent an employer would have to be running capability processes, formal capability processes, as it would do with somebody who's been employed for 2 years now, with people who've perhaps been employed for 2-3 weeks, and it's abundantly clear to the employer that their performance isn't at the required standard. The probation period allows that to be looked at in quite expedited way. So that would clearly need to change if unfair dismissal protection was provided from day one.
Yeah, absolutely. And we've had another question around redundancy and 2 years employment. So if an employee below 2 years employment and redundancy procedure is not properly followed, what could be the consequences, ignoring any discrimination situation? Well, I suppose the consequences, if unfair dismissal, there was no service requirement for it, so it was a day one right. If an employee at 1 year, for example, was made redundant and a proper procedure wasn't followed, that person would be unfairly dismissed. And the normal consequences would follow in terms of compensatory award. Whether there is a cap on that compensatory award, we don't know yet at the moment, depending on who wins the election and what the winner decides to do around that. For unfair dismissal, that the award's split into two. There's the compensatory element, essentially the financial loss. Then there's the basic award, sort of similar to a statutory redundancy payment, and we don't know I don't think we know how that would be calculated in the event of short service. It may be that that's a very small or nil award, and it would focus mainly on the future financial loss arising out of the unfairness. So it imposes the obligations we're used to for employees of 2 years onwards on, I should imagine, all of the members of the workforce.
But again, I mean, there's lots that remains to be seen.
Yeah, absolutely.
I think it's
I
think the webinar in July will be very interesting, but I would imagine that those sort of questions will still be unanswered by then, and we will have to see what a new government's legislative agenda will be over the coming months.
Yeah. So someone else has commented that day one right would lead to a significant increase in tribunal claims, and at the moment there's a long delay in that system. It'd be interesting to see whether the Labour Party, if elected, would provide adequate resources to the tribunals. If not, delays might increase, and that's an absolutely fair observation. And I think there is a sort of low-level fee on the horizon potentially, but that wouldn't in any way pay for an increase in further claims. And already we live in a world where cases often take, multi-day cases potentially take years to come along, when historically they might have been dealt with in 6 to 9 months. So the system is under strain. I don't suspect it's a high spending priority for anyone particularly, and so we'll only see how that will happen. I know that more judges are being recruited each year, which will help. Obviously, the digitization will help. Remote hearings helps. But yes, I agree that if there's an increase in litigation, there'll be an increase in delay. Good. Well, I think that's about right in terms of time. Thank you all very much for attending. There is, I understand, a poll which has been sent, feedback poll. So if you could answer that, that would be very helpful for us. And I'm hopeful that we will see you all in July to hear more details about what will then be the known results of the general election. So thank you very much for attending, and hopefully see you in July.
Thanks very much.